Mass employment claims are growing due to the removal of employment tribunal fees. In 2013 we had the introduction of fees which resulted in a 75 to 80% reduction in the number of claims. That was subject to judicial review, and following that they was abolished in terms of the fees. As a result, we have seen a large increase in employment tribunal fees, both just general claims, but also some of the more large-scale claims brought on the back of equal pay, collective redundancy legislation, worker status.
In 2018, which is approximately a year after the fees were removed, the group claims had increased by 344%. That said, there are also some other factors at play which really have an influence on mass employment claims. The first is that the type of claims that you can bring on a group basis in the Employment Tribunal have been very well publicised and have got quite a lot of notoriety in the press, including things like holiday pay and working time regulation claims. Those types of claims are now quite clearly able to be brought on a group basis, and I think that's had some traction with group claimants. In addition, the unions are very clear with their members that claims can be brought on a group basis and support claimants in order to bring claims on that kind of basis. And finally, there are specific law firms out there who also adopt claims on a group basis. So a number of different factors all at play, all contributing to the rise in employment tribunal claims on a group basis. So the types of claims that can be brought in the Employment Tribunal on a group basis are those claims which obviously have a shared basis in fact. So it's not possible, for example, to bring an independent claim with other claimants where those facts are different. So if you've been dismissed or you think you've been discriminated against, you'd have to find other people in a similar scenario in order to be able to bring a claim together. So for that reason, it tends to be claims or bases for claims that apply to large amounts of an employer's workforce. And those are claims like holiday pay, working time regulation claims, equal pay claims, mass redundancies, and also claims for the minimum wage. So those types of claims are those which can be brought by groups of claimants because they'll all be affected in the same pool.
Clients are concerned about mass employment claims because not only are the cost in terms of legal fees, the time in terms of management time and management cost in terms of defending the claims, but also the potential exposure. If I give you an example, we are dealing with a large-scale redundancy claim at the moment that's been brought by 1,200 employees. Depending on the outcome of that claim, the potential award could be multi-millions. And as a result, therefore, employers are clearly concerned about ensuring that they don't face or are successfully able to defend claims being brought.
It's also worth noting that the highest Equal Pay Act claim currently was 1.1 billion. So the types of money at stake is, like I say, very high. In addition, for claimants, it's very easy to bring these types of claims. So claimants can approach a union or can approach a law firm that does this type of work and take on a no-win, no-fee arrangement, or can be supported by the union in order to bring that type of claim. That individual will have to do very little work themselves, so it can just be added into the group claim and then submitted to the individual employer. The counterbalance to that, why clients will be concerned, is because for them to respond clearly is exponentially larger the number of claimants are involved. So the work the client has to do is always going to be much, much higher if the group exists and if the group is bigger. They're also notoriously difficult to manage, and that's because if you come to a certain milestone in the case, or you settle with one claimant, that has a knock-on effect. So you can find that claimants start to come out of the woodwork a little bit. So in other words, it's very difficult to keep control over the group and it can magnify. So the costs, the risks and the liabilities are very high in these types of claims, and therefore that supports the client's concerns.
Clients can mitigate the risk of mass employment claims by following due process, for example. So if it was a large-scale redundancy, following the process that has been set out by the UK statutory law and ensuring they comply with that in order to reduce the risk. In other areas such as equal pay, The issue is clearly then about whether or not there's an exposure, whether there is a difference in terms of pay. If they're then faced with a large-scale set of claims that are brought, then it's a matter of defending it in an orderly way and ensuring that test cases may be chosen and that a process is put in place, agreed with the respective lawyers on the other side in terms of how to manage the case.
Obviously, prevention is better than cure. If we can try to avoid the claims arising in the first place, then that will be the best way to mitigate these risks. If, however, that's not possible, or if employees still remain unhappy, obviously we can never remove the risk of claims coming in the first instance in any event, then the best way of managing the risk of these types of claims is to be incredibly careful and considered in the way that they're dealt with and the way they're litigated. For the client, it's important to understand what the aim is of the litigation. It's important to keep their costs and benefit under assessment at all times in order really to keep their arms around the cost, the risks and the possible liabilities.